May it please the court, my name is McColm, initial T, and I appear for the accused, James, a 14-year-old Aboriginal child charged with 5 counts of breaking and entering a premises and committing an indictable offence under section 421 of the Criminal Code, and 32 counts of burglary under section 419 of the Criminal Code. The defence makes application under section 590 AA, subsection 2, paragraph E of the Criminal Code, for the court to exercise its discretion to exclude the Crown's evidence of confessionary statements made by my client during an interview at the police station. Your Honour, it is submitted that the Crown's evidence, while ostensibly admissible, should be excluded based upon 2 grounds. Firstly, that the evidence was obtained in violation of multiple statutory requirements and therefore contravenes public policy. Secondly, due to the significant prejudicial weight of the accused's confessions, which likely took place due to gratuitous concurrence, admitting this evidence would therefore be highly prejudicial to my client. Your Honour, you're entitled to rule that my client's confession is inadmissible as a matter of law and was therefore of an involuntary nature. My client's confession was not made in the exercise of free speech or to remain silent. In dealing with the first ground, it is submitted that the evidence tendered by the Crown be excluded from trial as a consequence to the officer's failure to comply with legal obligations pursuant to the Police Powers and Responsibilities Act. Section 418 requires that a police officer must, before questioning a relevant person, inform them of the right to speak to a relative, friend, or lawyer, and must delay questioning prior to this occurring. My client was not afforded this right, which clearly proves a breach of duty from the officer. The defence submits that this is even more pertinent in the case of a young 14 Aboriginal child, as per section 421. It is clear from this evidence that the officer was aware he was interviewing a young person, as he referred to my client as young fella. This, Your Honour, is a problem, as my client is a 14-year-old Aboriginal child, and there has clearly been no attempt to comply with the provisions of section 421 of the Police Powers and Responsibility Act. On the evidence, the police officer has failed to provide my client with the opportunity of access to a lawyer or legal aid representative. Roger Smith can be clearly identified as a social worker, as per section 421, subsection 2, subsection A. However, he was not chosen by my client. This again is another statutory right not afforded to my client. Your Honour, in the case of Queen against Edel, there were similar circumstances to this, where a field officer for Aboriginal legal aid was not a relevant support person, as he was not of the defendant's choice. Consequently, this evidence was therefore ruled inadmissible. Your Honour, you may be minded to follow this decision today. Furthermore, my client was not cautioned in relation to his right to remain silent, pursuant to section 431, subsection 1 of the Police Powers and Responsibilities Act, and section 26, subsection 1 of the Criminal Code. On evidence, the only statements that was made to my client was from Roger Smith, who stated, "Well, just make sure you answer all the questions the police ask you, okay?" The defence's second ground, Your Honour, is the evidence ought to be excluded pursuant to section 130 of the Evidence Act, which preserves the court's right to exclude admissions of evidence in criminal proceedings if the court is satisfied that the evidence is unfair to the person being charged. The confessionary statements made by my client occurred due to gratuitous concurrence. As such, the confessions would be significantly more prejudicial than probative if admitted into evidence. As Your Honour is aware, gratuitous concurrence occurs when a person is not fully understanding of what is being asked of them and therefore agrees with everything proposed to them. This occurs when interactions with authority happen in order to convey cooperation or to avoid conflict. It is highly likely gratuitous concurrence has occurred, as my client, of Aboriginal descent, was clearly intimidated by the officer's approach, which resulted in him confessing to breaking into 30 houses crimes he simply didn't commit. The defendant submits that the confessional evidence did not understand or receive advice on the consequences of his answer. Your Honour, because of the presence of gratuitous concurrence during the questioning, the defence submits that it is appropriate for the court to apply Section 130 of the Evidence Act and exclude this evidence. In summary, Your Honour, the Crown's evidence against my client was unlawfully obtained as a consequence of serious breaches of obligations by the interviewing police officers. The manner of obtaining the confessional evidence, together with the gratuitous concurrence, are, the defence respectfully submits, sufficient grounds for the court to exercise its discretionary power to exclude the prosecution's evidence. Thank you, Your Honour. That is the case for the defence.